Hey, I'm firearms attorney Gilbert Ambler, and today we're going to talk once again about the ATF's notice of proposed rulemaking, where they're saying just about anyone who might sell firearms probably needs an FFL. And what we want to focus on today is we want to focus on the misleading way that the ATF has categorized the requirements and what you can in fact do if you obtain an FFL in the notice of proposed rulemaking. Before we dive into this subject, if you have not yet done so, go ahead. Hit that subscribe button for us, like our content, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. All right, quick refresher. ATF issued a notice of proposed rulemaking. We are still throughout the entire month of November, still in the comment period, so you can still comment and give the ATF feedback on this proposed rule. This is the proposed rule interpreting the Bipartisan Safer Communities Act legal change, wherein they go from a definition of engaged in the business, which says you are engaged in the business such that you are required to have an FFL to deal firearms if you are operating for the principal motive of profit and livelihood, and they switched it and said now you are required to have an FFL if you are engaged in the business of dealing firearms if you are operating predominantly to earn a profit. Of course, not a huge change there, so why did they do this? We covered this in other videos. Scroll back through our videos, you'll see us talk about this. But for the purposes of the quick refresher, my theory is that they essentially changed this language to allow the ATF to reinterpret it. Interestingly enough, ATF says that this terminology change was because it was too confusing for folks. Folks were getting confused over whether they needed to have an FFL or not if they were a dealer, that the term principal motive of profit and livelihood just confused them, so they had to go ahead and clarify it by saying predominantly for a profit. This is interesting, however, because the ATF, and in fact the government, the Congress, when they made this legal change, still uses the exact same terminology for manufacturers and importers and gunsmiths. So apparently this term, principal motive of profit and livelihood, is not confusing for manufacturers and importers. It's just dealers that are stupid and getting confused. So just a little bit of sarcasm here, because I think the ATF is really targeting people that buy and sell guns and not that interested in manufacturers and importers, because it's more difficult to engage in the business in that activity. All right, let's talk about how the ATF characterizes what happens when you get an FFL, the requirements to get an FFL, and what it allows you to do, because this is where I think they start to get a bit misleading in the notice of proposed rulemaking. A couple things I want to draw your attention to. The first thing that I want to draw your attention to is the ATF says there's all of these folks who might sell an occasional gun at places like a flea market or something like that. And if you're even selling occasional guns at these flea markets and things like that, if you fit into any of the presumptions that the ATF has, things like you're selling guns that are in like new condition, that maybe have the original packaging still, or if you've got a spreadsheet that tracks how much you spent on each gun, ATF says you presumptively are engaged in the business, you need to go get an FFL, and that will allow you to continue this activity. This is misleading, however, because if you get an FFL, you are then going to be subject to all of the requirements of having an FFL, including only being able to conduct business at your licensed premises or at an organized gun show. So there is no exception that allows an FFL to meet his coworker's brother's friend in the parking lot at a flea market and sell a firearm. So this activity that the ATF says if you want to keep this up, you need to get an FFL. Once you get the FFL, you're not going to be able to do that anymore. So a bit misleading on that part. The other very important thing is the time requirements, because the ATF estimates how much time it is going to take. In the notice of proposed rulemaking, they estimate how much time it's going to take to get an FFL. They estimate that it's going to take you about 5.5 hours on a yearly basis to get an FFL. They say that's selling maybe 2 to 3 guns a year. They say, look, we think it's going to take you roughly 3 hours for the initial inspection, roughly 2 hours, an hour to get photographs, passport file photographs, an hour to get fingerprints, send all that away, and then maybe a half hour in doing record keeping per year for those 3 gun transactions. And this is a hugely misleading figure. Not only do I think you are going to spend a lot more time on your Form 7 and a lot more time preparing to understand all of the requirements that are necessary for you and FFL to understand if you wind up getting an FFL. But I also think you are going to wind up open for business a whole lot more, because remember, the ATF is saying you are presumptively engaged in the business if you sell even something like 2 guns that happen to both be in the original packaging and in like new condition. So you need to go get an FFL. But to get the FFL, you have to have the intent to engage in the business. In fact, when we look at the Form 7, the application for an FFL, what you are going to find is that the Form 7 says you need to list at least 1 hour where you are open for business every week. And if you don't list at least 1 hour where you are open for business every week, the ATF might not approve your FFL application. Furthermore, if you say you are open during any given hour and the ATF comes to inspect you during that hour and you are not in fact open, that would be the basis for them later revoking your FFL. Because what they're going to say is they're going to say you denied us entry during the operating hours that you listed. That's a willful violation according to the ATF. They will then revoke your FFL and you'll never be able to get another FFL in the future. So what am I saying? ATF in their notice of proposed rulemaking says it's going to cost you about 5.5 hours a year. I would say it's going to be dramatically more than that, because they're going to want, per their own internal guidelines, they're going to want you open at least 1 hour per week. That's an additional 52 hours every year that they're going to want you open. Furthermore, this means the ATF, most of you, if you are subject to this rule and wind up going and getting an FFL to keep the ATF happy, in addition to all of those record-keeping requirements, you are probably going to be a home-based FFL. What does that mean? It means you're going to have a portion of your home where you're going to consider it the licensed premises, and the ATF can show up and inspect that on a basis of no more than once a year without a warrant. And it's an administrative inspection. Now, some of you in the comments will probably jump in and say, well, I've had an FFL for years and I haven't been inspected yet. This is true. Although the ATF is allowed to do these inspections on a yearly basis, often they're doing them every 3 years or every 5 years, or for small-scale home-based operations, even more like every 10 years. The issue is we know that enforcement has been ramping up. We've seen the request for funding. The ATF wants more funds, more agents. They want to come out and do these investigations, and they want you to have FFLs so that they can come in and do a warrantless administrative search and go through your records. And look, this is one of the things that I really hate about this idea. Are most ATFs going to go through the rest of your house and be poking through your bedroom during their administrative inspection? No, they are not. They are not. However, is there the concern that a rogue government agent, if they wanted to go through your bedroom and you have an FFL, could use that administrative inspection for the purposes of going through the licensed premises? I think it's a huge concern. For that reason, when I help clients do a Form 7, an initial FFL application, one of the things I actually do is I submit a blueprint of the house and I designate on the blueprint what area is the licensed premises. And I normally execute a lease between the FFL, the applicant, the homeowner, through his business entity and through to the homeowner himself. That way there is a lease renting this portion of the premises. That way we try to keep the ATF out of the rest of the house. This is just one example of the way this rule can go wrong. So what's my real advice to you right now? I'm sort of ranting and raving at this point about all the things I hate about this rule. My advice is, we're still in the comment period. Go write a thoughtful, intelligent comment. Tell the ATF why this rule is a bad thing, why it is unnecessary, and why really, when we talk about this legal change of predominantly to earn a profit, selling 1 or 2 guns, there is a specific congressional exception in the law that says you can sell guns to further a hobby. ATF is moving this line way too far down. Most of you that are buying and selling a gun here or there are doing it in furtherance of a hobby. The Congress has specifically recognized that you don't need an FFL for that. Go tell the ATF why this rule is ridiculous. Thank you so much. Until next time.